Now, PESA interest litigation, private interest litigation, and persona interest litigation. This is how the Supreme Court has decided some PILs while declining interim relief while hearing an application seeking the uploading of Form 17C data on the Election Commission of India website and the publication of booth-wise voter turnout data. Senior advocate Maninder Singh, representing the Election Commission of India, argued that such petitions attempt to keep controversy around EVMs alive and create false narratives. He contended that the application was based on suspicion and apprehension and was not maintainable. The case was being heard by the vacation bench of Justices Dipankar Datta and S.C. Sharma. The Supreme Court has raised several questions to the petitioner, which is the Association of Democratic Reforms, including why the prayers in the 2024 petition were not connected to the 2019 petition and why the plea was based on ECI press notes. The court stressed the need for caution in interfering with the election process, asserting a hands-off approach. The court also mentioned that such petitions may contribute to declining voter turnout by creating confusion. Let's go across to my colleague Harish joining us live at this point. Harish, some unexpectedly stern words coming out from the Supreme Court when it had to decline giving any interim relief to the petitioners in this case.
Yes, in fact, yet again, another snub to the EVM doubters and poll process doubters, as the Supreme Court has refused to pass interim order in petition which had sought uploading of 17C, that is the entire voting data per booth-wise data, and also direction to Election Commission of India to immediately publish all the data as far as voting is concerned, and questioned the sharp increase in the initial real-time voting data and the subsequent figures released by the Election Commission of India. But the Supreme Court said that these are agreed to the Election Commission of India's argument that these are nothing but another attempt to keep the controversy over the EVMs alive, spread a false narrative, and bring a sense, have a sense of create a sense of suspicion in the mind of voters. And Supreme Court said that we have to exercise the caution, especially when the polling process is on. We have to adopt a hands-off approach. We cannot interfere when the poll process is on, and question how the petitioners could base their petition on the press releases issued by the Election Commission of India. Let me, for the benefit of our viewers, read out some of the observations. How can your prayers be based on press note of ECI? We have to exercise some caution from interfering when election process is on. We cannot interrupt polls. We need to have a hands-off approach. These days, and this is very important, it says, these days we must say some of the PILs are PESA interest litigation, private interest litigation, and personal interest litigation. Supreme Court prima facie found merit in the argument of Election Commission of India that such petitions only attempt to keep controversies on EVMs alive in the midst of elections, and also agreed with the opinion of the Election Commission of India that we have seen a bit of a decline in the voting percentage this time. This is what happens when repeatedly, despite Supreme Court adjudicating on the issue and backing EVM-based elections, such petitions are filed and Supreme Court entertains it, and there should be an end to suspicion. And even only recently, the Supreme Court had backed the EVM-backed polls and said that we had in fact summoned technical experts and senior EC officials who have expressed explained in detail the polling process and had allayed the apprehension. So, saying so, Supreme Court has said that at this juncture we will not interfere, we will not issue any interim order, and kept the petition for further hearing post summer vacation, that is July 8th. By that time, the election counting will be over. So, vote counting will be over, which is scheduled for June 4th. Therefore, it's a big relief for Election Commission of India, as Supreme Court has refused to order uploading of Forms 17C and also immediate uploading, immediate declaration of voting data, and that day itself or within 48 hours, and not later as was being done in the past after past 4 phases of elections. So it's a big win for Election Commission of India, and yet another snub to the EVM doubters and poll process doubters as far as this case is concerned.
Thanks for setting it up for us at this point, Harish. Let's now bring in my panel who's joining me. R.S. Patania, spokesperson of the BJP, Advocate APS Khadial, spokesperson of the Congress, as well as Parvez Menon, senior partner of MZM Legal, is a very senior lawyer. Mr. Parvez Menon, let me come to you first. Your understanding of the Supreme Court's order, I'm not just looking at the decision to not award interim relief, but some of the words used in the order in order to describe such PILs as Paisa Interest League and Personal Interest League, and also, in fact, also saying that perhaps the less turnout we have reported so far in the election could even be attributed to the attempts at confusion which are being made by the filing of such PILs.
Tanshu, we must take a note of Supreme Court's anguish in their dictation. And plus, what the Supreme Court has said is paisa, private and personal. There are two more categories to add to this. One would be political interest litigation, and one is publicity interest litigation. So these are on the rise. We can read between the lines why people resort to such tactics when even the petitions claiming the same reliefs are pending in the Supreme Court. Having said so, on one side, do you imagine the mammoth task that the election commission is vested with to conduct election in the largest democracy of a country where 17C form updation is not even mandated by law? What the ECI is doing today is voluntarily they are updating the data, which is not required by law. The petitions questioning all of this is pending in the Supreme Court from 2019. Why can't you hold your horses? Why do you run to the Supreme Court at a drop of a hat for creating controversies in any given situation? So that Supreme Court was right in its conduct to say, wait, let the petition be decided. Come when your turn comes. Don't disrupt the process of election, which is sacred and sacrosanct.
Okay. Stay on with us, Parvez Menon. Advocate Khadial. Now, obviously, the main petitioner in this case was the ADR, Association of Democratic Reforms, but it was also argued by senior counsel from the Congress party, Abhishek Manu Singhvi. Another senior legal, Kapil Sibal, also came out with his views yesterday. How does the Congress feel? Does the Congress finally feel that with the Supreme Court adjudicating in the Election Commission's favor, it's time to now put this matter to rest? And along with EVMs, also bury this as yet another conspiracy which thankfully has now unfounded, and let us trust the EC in doing its job?
See, number one, you have mentioned it correctly that Congress party was not the petitioner. It was the Association of Democratic Reforms. Number two, every order of the courts can be challenged through a revision, through a review petition, curative petition. And therefore, I think what matters at the end of the day is that the Bharatiya Janata Party should stop cherry picking upon orders of the Supreme Court. They welcome some orders and they don't welcome some orders. For example, they say they welcoming this order, but when the Honorable Supreme Court had struck down the electoral bonds, Mr. Modi said it is a success story. Therefore, amounting to questioning of the Honorable Supreme Court. And number two, see, when the Honorable Supreme Court had said that the CJ is to be made a part of the selection committee of the Election Commission of India, why did the Bharatiya Janata Party have to undermine that order? Why did the Bharatiya Janata Party have to undermine the Chief Justice of India? And what problem did the Bharatiya Janata Party have if the CJ would have been a part of that selection committee? Because if the CJ had been there, it would only
APS
ensure
Khadial, you are an advocate. I'm sure we can stick to the issue at hand at this point.
It is.
The issue is not the BJP welcoming this order. The issue is about the merits of this order. And does the Congress party now feel satisfied?
No, 1 second, please. It is very much connected with the issue because if the CJI were a part of the Selection Commission of the Election Commission of India, that of course would have had an impact. And number two, the most important concern here is that the Bharatiya Janata Party should come forward and tell what problem do they have with the C-17. Why is the BJP quiet over this issue? Does the Bharatiya Janata Party not support C-17? Because there have been certain things that have been happening. We have all seen that there was one massive delay in divulging the information as to what was the voter percentage. Then we saw that there was a massive discrepancy of 6%. Have you ever heard of something of that sort? A discrepancy of 6% in reporting of the voter percentage. So these questions, they had to be answered and there had to be accountability for that. And if a petition has been filed by the ADR, I think we should realize one thing, that the order of the court can be challenged via a review petition. And number two, the Bharatiya Janata Party should come forward and specify the stand over C17 as to what problem do they have, and if the Bharatiya Janata Party also has a problem with the counting of the PVPats. Because the former Chief Election Commissioner, Mr. S.Y. Qureshi, had said back in the day that it won't take any more than 24 hours for the VVPats to be counted. And is the Bharatiya Janata Party against it? Is the Bharatiya Janata Party for it? Why does the BJP have to stay in the grey area? Why can't the Bharatiya Janata Party come forward and specify as to what their stand is about this? And the Bharatiya Janata Party should, most important of all, understand one thing.
Let's put those questions across. Let's put those questions across to the BJP. R.S. Patania is joining us. Mr. Patania, for a second, I request you to keep BJP Congress politics aside. Yesterday, the party came, the BJP on this very show, exactly 24 hours ago, said that we also want transparency. We also don't want any questions to be raised over numbers at this point. What are the facts of the matter? The facts of the matter is that these are unprecedented developments. For the first time, the final turnout of phase 1 was revised 11 days after the first day of voting. In the next 3 phases, it was revised after 4 days. The other unprecedented fact is the turnout percentages has gone up by 2 to 3% in all these phases, something which and my colleagues for about 10 to 15 years, this is our third or fourth Lok Sabha election we are covering, we have never heard or seen something like this happening. 1.07 crore voters have been added as a result of these revisions, which means about 28,000 voters per polling booth. Surely, there's nothing wrong in asking for transparency. And if there is a mechanism which is theoretically possible to make doodh ka doodh, pani ka pani, why should the BJP or any party be
Thank you.
Okay, I think we're having some. Mr. Patani, I don't think we can hear you as well at this point. Try.
I'm audible.
I'll try and come back to you at this point.
I'm audible, sir.
Yes, Mr. Patani, you're audible now. Please go ahead.
No, I'm going, sir. So my respective submission, sir, Bharatiya Janata Party stands for full transparency, full accountability, and full responsibility and full techno state of technology in the process of elections throughout the country also. So first of all, if we go by the judgment of the Honorable Supreme Court, there is a watershed distinction between obstructionism and constructivism. We need to be constructive, we need not to be obstructive by filing and firing such petition, and more so the environment which the Congress and other political parties have created throughout the country. We cannot doubt the institutions, we cannot doubt the processes, we cannot doubt independent and autonomous bodies. Though I'm not standing as a spokesperson for Election Commission of India, we need to be constructive. We need to come up with constructive ideas. And so far, we were referring to the fluctuating of the overall percentage. If you see, first of all, at 6, at almost 10 minutes less than 6, a final tally is taken. Sometimes there are EVMs, may it be Jammu and Kashmir, may it be Assam, may it be certain hilly areas also. So some EVMs come thereafter also. Then there are postal ballots also. So this is the only reason why the overall percentage rate fluctuates. This is what my understanding of the election process says it. But just we say just to create a storm on the drop of a hat. This is the way we couldn't go ahead. My respectful summation is that democracy cannot run ahead once we keep on demonizing each other. We need to trust the institution. We need to be constructive. We need to be contributive.
And Parvez Memon, where do we draw the line? And
that's
go on. Complete your point, sir.
That's what my learned friend was saying. That Supreme Court has again and again said that public interest litigation have been turned into publicity interest, personal interest, and political interest litigations also. So, although on the other side, very beautiful judgments, very beautiful orders, and very constructive ideas have come through while filing certain cases in the Honorable Supreme Court and various high courts also. Various grey areas have been pinpointed by the petitioners also. But that's not only the case that only the petitions in the courts, they are running the system and the processes also. So as you put your question very rightly, there is a watershed distinction, and we need to understand it. We need to appreciate it. We have our rights also, but we have certain duties also. We need to follow that.
Fair enough. Let me quickly go across to Parvez Memon, sir. where do we draw the line between, and
That's it.
where do we draw the line between obstructionism, which is for the sake of creating politics and over, okay, with this rule book is not fair in my favor, system is rigged against me, and so, which any political party which loses tends to do, and where do we bring in genuine need for reforms and at this point a constructive criticism coming in at this point? Let's give the EC its due. It has this voter turnout app, which anyone on my phone and on phones can go and see the turnouts live at this point. They're indicative, but this is the level of transparency of communication that was unheard of even a few years ago at this point. But at the same time, if there are efforts in which we can make it even more transparent so that there are no doubts as such over a democracy or the world's largest democracy and how it functions, shouldn't these be welcomed instead of coming up with words such as Paisa interest league or political interest litigation?
Yeah, Ritanshu, see, there are three aspects to this. As is the principle in law that where there is a right, there is a remedy. Now, Form 17C is to be submitted invariably to every candidate or his representative who is present in the booth. Now, if there is a dispute regarding one particular booth that yesterday the ECI submitted to my representative, say 1 lakh votes have been casted, and a day after tomorrow the figure goes up to 1,25,000, then that particular booth or that particular aggrieved candidate has all his rights to explore in law to go to the particular high court where in that state. Why is everybody rushing to the Supreme Court is question number one. Question number two, when there is no law for making 17C mandatory public, the legislation has to be amended to that effect. And number three, to address the situation is even somewhere I find that the Supreme Court should have decided the petition filed in 2019. If the petitions filed before the previous elections are kept pending for the current election and are to be decided even thereafter, there is some delay somewhere. Something has to be drawn. We have to have a black and white script written that this is the mode of functioning, this is the remedy available to the people who are aggrieved, and this is the forum to approach. Everybody knocking the door of Supreme Court is also not appreciable, and no reprieve for people who are aggrieved is also not appreciable. We have to draw a balanced line in the interest of justice.
All right. On that note, we'll have to wrap it up here, but we will continue to focus on this, especially at 8:30 p.m. today on the Urban Debate. But R.S. Pathania, Advocate Khadial, and Parvez Menon, thank you so much for joining us with your views here. This is something which is very important for India's democracy, and it should not be sidelined or neglected.